All right, good morning. We are on the record today for the 28th Circuit Court here in Wexford County. And we are beginning today by taking up the case of People of the State of Michigan versus Brandon Michael Sias. This is file number 25-14000FH. Appearances, please.
Joanne Carey for the people.
And I'm Jeff Harrison. I'm here on behalf of Mr. Sias.
Yep.
He's next to me at the table.
Thank you. Also here this morning is Mr. Kevin Stapleton. He is the agent from the Michigan Department of Corrections who has prepared today's pre-sentence investigation report. The court has received a copy and gone over it. I didn't catch any need for correction myself. It's a relatively shorter report. And based upon a 10-year gap, there's not a lot of criminal history here to reference. So, Ms. Carey, any amendments, corrections, or objections to make to the contents of that report?
Don't have to the report. I do have a victim's statement that he wants me to read. He's not present, but he did provide one.
Of course, certainly. Mr. Harrison, anything to challenge regarding the report?
I don't think so, Your Honor.
All right, thank you. Ms. Carey, why don't you go ahead and read that statement provided by the victim?
His name is Charles Sampson. He writes, I am at a loss for words still over a year later. The anger that comes with it is very difficult to control whenever I think about it. All the time and money I had put into my house that I owned, paid off, gone because of someone who had absolutely zero respect for someone else's belongings or livelihood. He had no financial loss for it, so why would he care? How will I ever be made whole again with the person when the person has nothing to begin with? I believe I should be made whole again. I have lost an unknown amount for missed rent. I have a $1,700 water bill, in part because of Brandon. I don't know what to think about sentencing other than how can someone have so little respect and complete disregard for someone's belongings and property. He did nothing to deserve it. I am out of a house and countless other things, and he is out nothing. He has a roof, 3 hots, and a cot this past year. If I didn't have people that cared, I wouldn't have had a roof over my head, even though I worked my butt off and owned a home. He also provided a receipt for $19,436 for plumbing services, but we are going to ask that restitution be held open because he's going to try to provide some more.
Thank you. Ms. Carey, allocution then, since we're already over at your side.
Well, I can't say it usually much better than the victim said. He's very, this cost him a lot. Mr. Sias, the defendant, did a lot of damage. He intentionally started this fire. He went next door and grabbed a gas can and took it back over to the residence and sprayed the gasoline inside and lit it on fire. That's very intentional. It did cause a lot of damage. There were other people in the home at the time who had to flee. But I understand the recommendation. I understand the sentencing guidelines and that he's been in jail now for quite some time. But
So were there people in the building when he set it on fire?
yes,
How come we don't have a scoring for number of victims if we had people that were placed in danger of injury or loss? And I don't know, like how, like where were they sleeping? Were they?
pretty sure there were a very good question.
Yeah.
It should be scored.
I don't know why there's no scoring for offense variable number 9. And contemporaneous acts. What about the property damage? Right now, we have at least enough to score 5 points for OB 60. How much money did you say it was worth? 19,000?
That's the a plumbing bill, 19,000.
Oh, What about the damage to the building?
We don't have any information on that yet. That's,
Was it destroyed?
Well,
If
it wasn't a total loss, is my understanding.
and our understanding is that that building had been condemned prior to the incident. Obviously, we'll flesh that out if we have to.
Well, there should at least be 5 points scored for offense variable 16. Whether or not it was condemned, it could have been repaired. I don't know what the value of it was. Was it a residence? Wasn't it
It was a house,
a house?
correct?
So did it at least have a value of $1,000 or more?
Would say yes.
Oh, there were people in it.
I can't find their names, although it's a known name. Stephen Petrovich and Abigail Southwick, I believe, were inside the house and had to run out.
Now, we had a couple very common names here in the courtroom, but sure. 2 of them. So you've got a number of victims, 9. We're going to add 10 points to offense variable 9. And we're going to add 5 points to offense variable 16 to recognize the property damage. That's going to give us 15 points. It's not going to really do much of the guidelines. That's going to keep it the same. It's going to still be an intermediate sanction cell, but we want to cover this damage. That is on E-grid. So if we have those 15 points, that's going to give us an OB level 2. All right, and that's only going to change the range from 0 to 3 to 0 to 6. All right. And what we're doing there is we're acknowledging some of the damages in accordance to the points, but I'll tell you, if we see an arson sentence, can't imagine how nobody put in OB points. I don't know if we needed to have that done. My suspicion here is because this case is kicked around for over a year, maybe it was just quickly done. But the value of the property, if it could have been more, then there could be more points. Now, I'm not going to say that that's going to change the guidelines much. In fact, it takes 9 more points even to move it from OB level 2 to OB level 3. And that would still only go up to a 0 to 9 month range, which is still an intermediate sanction cell. But my suspicion is that when we see when some are seeing an intermediate sanction cell, they stop and they don't go back through and do enough scoring. All right, thank you. Mr. Harrison, allocution.
Well, indeed, I think on one hand, it's pretty easy to look at this as pretty open and shut. It's a plea to an attempt 3rd-degree arson. The guidelines are low. The jail credit far exceeds the county year that's called for in the recommendation. But I think it behooves me anyway to say a couple of things about Mr. Sias that I've gotten to know in over a year that he's been under my wing, so to speak, as a client. The court will recognize and remember, so stop me if you've heard this one. This case had sort of a circuitous path because it found its way through the forensic center system. And there was an initial determination, if I remember correctly, that he was not competent, and that later changed, and it turned out that he was competent, and we were able to resolve the case. But it took a while to get him there, so it does appear to, at least to me, that part and parcel of what was going on that night was some kind of mental health crisis on his behalf. Even subsequent looking at the cases with him, now that he's in a much better, clearer thinking, relaxed state of mind, it's met with some degree of disbelief by Mr. CS because he can't put himself back in the shoes of the person that did this ridiculously stupid and ridiculously destructive thing. I'm confident that he is currently getting the correct care, he's getting the correct medications, he's getting the correct insight into his own thoughts and actions that he will need to garner for the rest of his life, because this is not something that's going to go away. It's treatable, obviously. It's something that he can manage, obviously, but it's up to him to do it. I think this is an example of a court system and a mental health system that has done everything it can for the individual in question. And it's now time to kick him out of the nest and let him fly free. Can't say enough about the impact that just simply getting on the right medications seemed to have on Brandon and his thought process and the clarity of his presentation, et cetera, et cetera. So I'm very pleased about that, and so is he. He does enjoy the support of his family. Unfortunately, his father lives in Wyoming. And as mentioned in the PSI, his eventual plan is to go back to Colorado, but there's a great distance between Michigan and Colorado physically, and there's a great distance between his current situation and his old life psychologically. I'm confident he now has the ability and the tools to work through all of those issues and present a clear path for himself into the future. I don't believe this is the kind of behavior he's ever going to repeat again, because of the fact of the ordeal that he's been through, not just being in jail, et cetera, but the whole process of recovery here has been rather torturous. So I think it's a lesson well learned on a number of fronts. It took us a while to get here, but I think we're here. And I think this recommendation is appropriate under the circumstances. Thank you.
Thank you. Science, you have the right to make a statement if you choose to do so. Is there anything you wish to say at this time?
Sir, I was surrounded by a bunch of demons at the time, and I was having trouble getting the devil off my back, and I had a panic attack, and I feel terrible for what I did. I needed help. I was at 125 pounds when I got in, and I'm at 175 now, and I feel much more healthier. I'm on the right meds now. I can think clearly. I'm not battling any demons anymore. I do plan on making it right with Mr. Charles. I do jewelry on the side and hope that I can come up with enough stuff to pay him off to make it right with him. There were people in the house at the time. I told them before it happened that I was about to try to start the wood stove on fire to get the house heated up, and it went bad. I decided to put gasoline on the trash piles before I put them in the wood burner instead of just putting the gas in the wood burner itself. And I ended up sparking a fire and got out of control. I apologize. I really do. I feel sorry for Mr. Charles, and I hope he forgives me.
All right, Mr. Stapleton, I need to ask you a question because we haven't, I don't think we've ever had this before. On criminal history, he got 217 days for an event that took place in the jail. How do I give him credit for that 217 days if that was his sentence? Because he was in jail on this case, then committed an offense on February 21st of 2025. The conviction was in November on the 12th. He got credit for time served. How do I give him credit for that time if he was serving a sentence?
I think you're correct. I don't think you would. I didn't catch that. It would, I think it'd be minus the 217 days.
All right. So we need to put a guideline, we need to change CFJ 145, page 2, deduct from the date range of February 21st of 2025 through November 12th of 2025. That will reduce it to 217 days down to 209 days. Then he'll get credit for this, which will also change the credit on CFJ 145, page 1. Okay. So that still, however, is above the guideline range of the 0 to 6 months. All right. I somewhat here also at a loss because the description of the offense and everything we just talked about changed by the time it got to the defendant. The defendant statement basically tried to make it sound like an accident or a confused accident or something. I don't know. However, we're here today after the defendant entered a plea, was one of no contest. The court accepted it as such. This case at one time was a CSC, I'm sorry, not CSC, sorry, an arson second degree that would have put it on the B category. He would have faced there a 12 to 20 month potential sentence. However, that's not the chart that we're using based upon the plea. So to the victim in the case, that is somewhat a reduction, went from 12 to 20 down to a 0 to 6. Court's hands are somewhat tied here because of the way the case has been resolved, and I'm not challenging the way it's been resolved. I'm just explaining it so in case the victim is ever goes to look at the review the sentence, review the court's explanation, that victim understands that the sentence today is based upon the pretrial agreement, and that has brought it down from a potential prison sentence down to an intermediate sanction cell. The court is not allowed to, the court is instructed by the law to begin with a presumption of probation, fines, and costs. However, court can take into consideration whether or not there are reasonable grounds for a period of confinement. Well, the defendant does have some prior criminal history, although it's relatively minimal. The defendant did, however, commit a criminal act while in the jail. Therefore, the court does have some reasonable grounds. Now, this is a long way to go about justifying the sentence. And yes, we are here in part because this case is kicked around due to competency and responsibility questions. So with all that said, I don't think probation is necessarily an issue here. The court sentences the defendant to 209 days with 209 days of credit, a $68 state minimum fee, $130 crime victims' right fund fee, a $300 court costs considering the length of time which this case has been pushing in and out through the system. The court is not going to set a fine, again, no fine. An attorney fee of $300 to cover the expenses somewhat for the representation of counsel. Do we have any DNA fee here that I need to account for?
Yes, $60 to the Wexford County Sheriff.
$60 DNA fee payable to the Wexford County Sheriff Department. There will not be any supervision fees. And then restitution will remain open for 30 days. To the victim, let's be realistic, your likelihood of getting any restitution here is probably quite low. And definitely the amount that you're gonna get over time, it's not gonna reach the nearly $20,000. Find this sentence is reasonable and proportionate. Again, the anger felt by the victim is quite understandable. The law, however, ties the hands of the court to a certain degree. And my sentence is completely, I believe, within, well, technically it actually exceeds the guidelines, but I have to give him credit for the 209 days, so he's already served the most that I can really give him under the law. Missed anything, Mr. Stapleton?
I don't believe so, Your Honor.
Miss Carey?
No.
Mr. Harrison, any questions about the sentence?
I have none so far.
Mr. Sias, Mr. Harrison is going to bring to you 2 copies of one document. You're going to place your initials on the first copy. Doing so neither elects nor waives any rights. It merely acknowledges that you have received the other copy. Now, this document tells you that you have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal. However, based upon the plea in this case, any appeal must be done by filing filing an application for leave to appeal and not a claim of appeal by right. So if you wish to have the court appoint an attorney to assist you in appealing, which of course your sentence is done today, you can complete the bottom half and turn to the court within 42 days. Do you understand? So while this is a departure within the, or outside of the guidelines, the court finds that departure appropriate, because all I'm doing is really giving him credit for the time that he's already served. All right, thank you.
Thank you, Your Honor.
Take care of yourself. Yeah. May I approach?
You may, sir. Thank you. All right.